This is a part-heard appeal in the matter of Sahara Energy Resource Ltd and another, and Société Nationale de Raffinage SA.
Yes, Mr. Hussain.
My Lords, I'm still on ground one. I'm going to focus now on the actual construction of the document, the narrow view, for the narrow approach. To save some time and mindful that we don't have a live transcript, I prepared a speaking note that I've shown my learned friend, which, if you don't mind, I'll send up to the court.
Thank you.
I was going to suggest that we hold open against this the joint report, my Lord, which is at Core Bundle tab 7. I'm really focusing on the resolutions, and then circling back to the titles. And the way that the note works, I'm obviously going to go through it, is that anything in red is the wording from the actual document. And what I want to start with, my Lord, we've obviously seen the tables already, but I want to focus at page 47 on the word resolution. And I say that the word resolution is significant. It is a word of the party's choice. And in my understanding or my submission, the parties emphasize each of these as joint declarations, as points of emphasis and importance of the parties' positions. I'm going to call them resolutions 1, 2, 3, and 4, following the order of the bullet points. So we have resolution 1, which says all relevant supporting documents for the claims have been submitted by Sahara and duly acknowledged by Sonara. That's to a large extent self-explanatory. But what I would submit, and this is my understanding, is that there were no supporting documents for the principal or contractual interest. That was simply a matter of arithmetic. So the supporting documentations that were acknowledged and announced as submitted relate to the undisputed claims and possibly the disputed claims. We then look at resolution 2. Sonara will review and collate the documents for submission to the government of Cameroon. And Sonara says this is a matter of, this is a resolution of importance, significance, because the parties are going out of their way to emphasize that there will be a submission of the supporting documents to the government of Cameroon. And we say that this has to be, or this should be considered in light of the judicial factual findings that I've set out at item 5. I'll leave it to your lordships which ones of these you think fall within the scope of admissibility, and I'll go through them. The first one, which I don't think it is debated, forms part of the legitimate commercial background, is the finding that Sonara was in a financial crisis and dependent on the government of Cameroon for support. We have the second one over the page, that there had been a number of reconciliation meetings where Sonara had made clear that they were not persuaded that the claims fell within the boundaries of their contractual liability. That's from paragraph 138. And again, I'm mindful, my Lord, that yesterday there could be a distinction whether this forms part of the commercial background or whether it's looking at previous negotiations. So obviously this may not fall within the narrow view. Similarly,
when you say claims there, can you just be clear what claims you
yes, so I should
are talking about? I mean, that is a direct quote, I can see.
Yes, I'll take you to it, my Lord, because I have put a dot there. And it might be helpful if we, I don't want to open up 3 things at the same time, but if we have the judgment, which is at Core Bundle, tab 9, so this will be at 117. And my reading of that is the reference to claims there, if we read the preceding paragraphs, is to the claims that were being resisted as a matter of principle, which would include the Forex claims and the incremental interest claims.
Where is it? Incremental interest, FX, and penal charges, presumably.
Yes, although the judge isn't talking about that here because obviously it wasn't a position before her that those had been agreed, but they would fall within the same.
So it's
Same
the
item.
incremental interest or FX
Yes.
that's referred to, yeah.
And then if we go, the next item I've identified, this is a factual finding. I mean, it's a question for your lordships whether it can be part of the commercial background or not. But there was a factual finding if you go to page 116. Paragraph 133. Roman 3, where the judge says there had been two areas of discussion over the years, one as to the maths and one as to liability. Again, that's a finding of fact. Whether it's relevant or not is a separate issue. And then item 4 in my note, which is another factual finding that I say is relevant here. It's at, bear with me, I forgot to put the paragraph number. I believe it's
139.
I'm grateful, my lord. It's 139. There is a fact that the parties knew that Cameroon government agreement would be needed for anything not demonstrably due from Sahara, particularly in light of the financial crisis at Sahara caused by the refinery fire in 2019. That, I say, does easily fall within commercial background because it's about the parties' knowledge rather than what they were discussing.
And assuming that it does, what do you say the word demonstrably means?
Well, I think it links back to the point that there had been on record a position that these claims are not due under the contract, and it could also mean that there would have to be a demonstration of the mathematics, hence the supporting documents being collected. So I highlight.
I'm not sure that's an answer to my lord's question.
Sorry.
Demonstrable by a court judgment in Cameroon. Demonstrable because Sahara could satisfy the government that Sahara felt they were sufficiently demonstrated.
I would say demonstrable to the satisfaction of the government, or objectively demonstrable. I don't think it goes as far. The judgment doesn't go as far as to say it would only be.
And
there were
it's
court
your submission that these claims aren't, that incremental interest wasn't demonstrably due, even though that was what the judge has found.
So just taking that in stages, my position is that the joint report read as a whole, including in particular footnote 2 and footnote 4, sets out that Sahara is not committing itself to liability unless and until it's heard back from the government of Cameroon. And I'm relying on footnote 2 for that. I'm also relying on the judge's finding of a fact, whether you think it's relevant or not, that the parties knew that that agreement from the government would be needed for them to fund any liability.
So can I just pursue that? I understand your point that you're saying quite independently of paragraph 139 that there's a footnote in the report that you say amounts to a condition precedent, no liability unless the government of Cameroon has agreed that the company can accept liability.
Yes.
I'm just trying to unpick what you say the judge meant, or what you're saying you can get out of what you say is a finding of fact of paragraph 139. Just unpicking it, looking at it again, then there is the fact that the parties knew that the Cameroon government, or that Cameroon government agreement, would be needed for anything not demonstrably due from Sahara. Now, when it said needed for what? Needed for payment of anything not demonstrably due, or just needed for Sahara to accept liability? Because what the judge goes on to say is, particularly in light of the financial crisis, Sahara was dependent on the government of Cameroon for support. And was the judge saying that everybody knew that a liability couldn't be paid without government support? Or is she making a finding that says no liability would be accepted unless the government agreed? Because the point was made against you, I think, yesterday in argument, that in order to get the Cameron government to provide the money to pay, the company Sahara would in fact need to accept liability, because it was only if they accepted liability it would become a demonstrably due debt. So they try to put, well, you would say, the cart before the horse, but they say you're trying to read too much into that factual statement. Have I sort of explained?
Yes, and that's a very apt way to describe the point of difference between us. In response to your particular question, I say that the judge is saying both. She is saying that that Sahara would not agree liability, unless it was happy that the government would be willing to pay for it.
And where does the judge recite the evidence to support that statement of fact? Or what is the evidence that either the judge gives or was available to her to support?
I'm going to go through some of that now.
May I just follow up from my lord's question, please? It seems to me that potentially your position is slightly circular on this, because if your client will only agree liability if the Cameroon government is satisfied that there is liability, but your client is maintaining there is no liability. So how is the Cameroon government ever going to be satisfied there's liability? As you won't agree it until the Cameroon government has agreed it, then how will it ever be sorted out?
Well,
surely, just to finish the point, surely the Gordian knot is cut here by this very exercise, which is you sit down with Sahara and reach a binding agreement. So you then go to the Cameroon government and say, look, this is what we have agreed. We've agreed some things, we've agreed we're not liable for some things, or disputing some things, we've agreed certain other things are we're liable for, so now you can pay.
my lord, I don't.
I may follow my lord's point. I'm trying to avoid sort of doing a relay here or tag team here, but to what extent do we need to understand the relationship between your client and the government of Cameroon?
I think that relationship is a very important part of the commercial background when you're looking at these footnotes and the discord between the title, undisputed, and the footnote. And in answer to your question, we submit that there is nothing strange about this. Sahara was a wholly owned government entity. It had no money. So it would be madness for Sahara to make itself liable for something without speaking to the government. And that is why we say this was an agreement to agree. And that is why we say we have these if everything was agreed, why would you have a footnote saying, a resolution saying this will be submitted to the government? What business is it anyone's what's submitted to the government or not, let alone as a resolution?
It was common ground that you would need before you could indicate what payment terms you wanted. You would need to consult with the Cameroon government to know what funding they will provide when, even for admitted payments.
Well, that agreement, we said that we will need to more than that, but that I understand to be an agreed fact. So that fact again goes against us because, my lord, we're discussing the payment of a debt that's now been claimed for, from memory, 4 or 5 years now. So the idea that the timing of payment is not an essential term is nonsense. So even if all we needed from the government was to come back and say, well, we pay you in 2 months, 5 years, 6 years, there's an unreality in saying, well, actually that could all be sorted later. And I think this is where I'm going to. That although, and the judge said this, that the headline undisputed leads you to a certain direction. But when you start looking at the resolutions, particularly 2 and 4, in light of the reality, the commercial background, you're left with a nonsensical argument that a wholly owned state entity that has no funds is going to bind itself to pay 70 million US dollars without speaking to the state, and the parties are going to leave over for further negotiation when that payment is going to take place.
Well, forgive me, but why is that so if the limitation period is about to expire? Your express agreement that you're liable is rather important in that context, which is exactly why we're here.
But I'm not sure that that's a relevant point. That was a submission put to you yesterday, but that might go to whether or not there's been an acknowledgement of the debt, and we can look at that. But there was no suggestion in any of this meeting that we're here because of a limitation period. It was never put to any of the witnesses. I think the first time I heard that was yesterday, and I think that's more of a jury point, a sympathy point. But there's never been any suggestion that someone said, well, we're here because the English law limitation period is about to expire.
There were lawyers present at the meeting.
Yes, but there's...
It must be taken to be aware of when the limitation.
No, there weren't English qualified lawyers. And then we're really getting into, my lord, much more of a wider stance.
Investigated at trial.
It was never suggested that this had anything to do with the limitation period till Mr. Young said it yesterday. It was never put to a single witness. Just going to Lord Justice Snowden's point about the evidence. So I've put at item 6 of my note onwards some of the transcript. So if we, it might be easier, my lord, to go through my note, but I'm happy to take you to the transcript as well.
Do I understand, though, that by the fact that you have gone through the evidence, that you can't point to any paragraphs in the judge's judgment which she would have been relying upon to support that statement in paragraph 139? Does the judge refer to any of these parts of evidence?
I think I need to check that, my lord, but I think it was actually submitted by Sahara itself that there was no money unless it came from the government. That part was submitted.
Yeah, but that doesn't carry us. If you're asking us to read paragraph 139 as being just there was no money unless it came from the government, I think you're a long way from getting home. If you're asking us to read paragraph 139 as being there would not be any agreement by Sahara to a liability unless the government of Cameroon authorised it to make that agreement,
There is no...
Then your point, I can see your point, but I'm asking you, does the judge provide any evidence that might substantiate that reading of paragraph 139? So does she make any findings that would support that assertion?
She doesn't identify any evidence, no. But I say that that is firstly a finding that she made that is not being challenged.
Well, it's a finding which it seems to me, at least speaking for myself, at the moment, as stated, the finding is ambiguous.
Mm-hmm.
It's not clear to me whether it simply means agreement would be needed to pay anything not demonstrably due, or agreement would be needed before Sahara could concede liability for anything. And it seems to be, when I put it to you earlier, what sense should I read that in? I think you said you could read it both ways. I said that about 5 minutes ago. So I'm trying to unpick which of the two meanings, if this is relevant or admissible, or if it's something we should take into account.
I would say the broader meaning. The reason I say both is obviously because if you need their agreement to agree the liability, you also need their agreement to how much money you're going to agree to be liable for. So one follows the other. I think we are getting into the danger of Volpi territory, where we are then trying to summate a perfect judgment with respect.
It's you that are trying to rely upon. Sorry, isn't it you that's trying to sort of guide us through the factual side? I mean, Mr. Young, I think, at least before us, has at least accepted perhaps a rather more pared down version of the approach to contractual interpretation.
Yes, my lord. I'm trying to keep it pared down. It's just, I mean, I'm relying really on resolution 2, but I'm trying to give you as I go along the relevant factual findings, I'm accepting that some of them you may say, well, they are not within the canons of contractual construction, and I'm trying to as fairly say which ones might fall on the other side. But at the very least, it would be part of the commercial background, as you've accepted. You may say it doesn't take me very far, that the money had to come from the government. We then have, I've put in some of the evidence, item 6 of the note, when Mr. Fadipe, one of Sahara's witnesses, was re-examined by Mr. Young KC. He said, with regard to the second bullet point of the resolution, Sahara would review and collate the documents for submission to the government of Cameroon. What was the function, as you understood it, of the government of Cameroon in this matter? And he says, thank you, my lady. Sahara, to the best of my knowledge, is a state-owned company, and the majority stake in this asset was held by the government of Cameroon. I think at some point, I'm not sure if it still exists, but I know Total also had a very minimal stake. To that extent, since this was an issue that was already, that appeared to be out of the control of Sahara in terms of the exposure, the volume of exposure, and the fact that Sahara seems to have been choked by this exposure, it appeared that the government's intervention at that time was required. And this, I submit, chimes with the importance of Resolution 2, which weighs heavily in my submission towards this being an agreement to agree, i.e. an agreement subject to what the government had to say before liability would be accepted.
It strikes me that's just an answer that they're dependent on the government to fund it. Isn't that what Mr. Phillips is saying there?
Well, he's asked, why did you put in that second bullet point? He's specifically asked that by his own counsel, and he says that this was an issue that appeared to be out of the control of Sahara. I mean, he could have said this was just an ornament. It wasn't important to us. We didn't really care. I mean, there's no explanation as to why there is a resolution to this effect if the agreement is complete just by using the heading undisputed. Why do we have this resolution? And what are we meant to make of it?
We're now looking at interpretation. We have to look at the whole document.
Yes.
And we take into account the factors. But then we also have to look then at the parties were perfectly capable of including at the end this agreement will be submitted to Sahara's banking and legal partners for validation in capitalism in bold, which seems as a clear, making it clear that there is a condition or precedent or subsequent on Sahara's being bound by what is in the agreement. And when we compare that to the simple wording, submit the documents to the government of Cameroon, it's hard to construe that latter, actually its former in the document, as being of the same nature and quality as the words in capital and bold, isn't it?
I'm sorry, I don't agree with that. I'm not sure why the syntax of the document in that respect. The resolution is also in capital and bold and underlined. But I think we haven't.
I'm sorry, the wording, that's certainly the heading, I agree, is in resolution in bold. But that's not the main point. The main point, obviously, is the wording.
I don't see.
The point is simply the parties where, this is an ordinary incident of interpreting the document, where the parties intended to make something a condition or reservation as to the binding nature of their agreement, they are able to say so expressly and clearly. So why should we construe something which makes no reference to validation or condition, simply submitting documents as having the same effect as what is in the final words of the document? That's the question.
So I'm just struggling a little bit, my lord, with your question, just to understand it. I understand your point that you say that more words could have been put in footnote 2. there's no suggestion that the words "this agreement will be submitted to Sahara's banking and legal partners for validation." That means that the banks or the legal partners somehow have to agree to the agreement. I mean, it's just an acknowledgement that it's going to be shown to other people. No one has suggested that the banks. I mean, I don't even know. I don't even know, and it's never been suggested who legal partners is.
I think the solution is that that is what validation means.
That the banks would agree with this compromise.
Well, that's certainly what was put in the skeleton argument of Mr.
I have
Young,
not
and
seen any
certainly
agreement.
What he submitted to us yesterday.
I'm not.
That's what he says it means.
Okay. Well, the banks have never agreed to the compromise. Have we not been shown anything where they've agreed to it or even validated it? I'm not sure what the argument is.
But it's in the document.
Yes.
Sorry,
but-
it's a very simple point. I may not be explaining it very well, but on the face of it, that shows that where the parties wish to make something, at least on the face of it, requires validation from banks. Why did they not say it required that the undisputed claims required validation from the government of Cameroon? That's all I'm asking.
Yes. It could, I mean, I take your point. They could have used that word, but they didn't.
But why doesn't one imagine an interpretation that reads something into that?
Well, we're reading the resolutions as a whole, 2 and 4 together. I take your point that both 2 and 4 could have been a lot clearer, as could the headline either way. So I'm not able to submit to you, my lord, that the parties have said for submission to the government of Cameroon for ultimate approval or something like that. They haven't used those words. But what I'm saying to you is that when you read this, in light of the commercial background, why would you be submitting to the government of Cameroon if the matter had already been agreed? I don't understand, and I never have understood, that it's being suggested that at page 48, there was no joint agreement. There was no binding agreement till the banks had somehow validated it. I do not understand that to be the case. I think what that was an acknowledgement of was that this document would be shown to certain people.
My understanding of Mr. Young's submissions was that he was saying that that bold, capitalised language amounted to at least, I think, a condition subsequent. I think he corrected me and said he thought it was probably technically a condition subsequent, but certainly a condition to the enforceability of the agreement. But whether or not he's right about that, my lord's point to you probably still runs to this extent. What you are now saying that the second icodot on page 47 amounts to is a condition precedent or condition subsequent to the enforceability of this agreement.
No, I'm not saying
You're
that.
not saying that?
I'm saying that as a matter of construction that points to the fact that nothing is being agreed because this matter is going to be put to the government of Cameroon. It's a pure construction point.
Isn't that what I mean by condition either precedent or subsequent?
Yes. Sorry, I thought you meant. It's,
So,
Well, not quite. I think what you're saying is that shows that there wasn't yet a binding agreement.
yes.
What would then have happened if and when, if you call it a condition, the condition were fulfilled, i.e. the government said yes or no, wouldn't have itself have given rise to an agreement. It was going to have to come back because that was going to be the subject matter of the further negotiations.
Yes. So my point is that these words, it might be.
Analytically, it may be slightly different. It may in practical terms be the same if the government do say yes, but analytically, I think you're saying
I think that the construction.
no concluded legal agreement until it's been considered by the government.
Yes. So the point isn't necessarily that it's setting a formal condition subsequent. It's just simply stressing nothing is agreed yet because these things are still.
I think in my simplistic way, I'd probably call that a condition precedent. But anyway, take your wording, it's easier. Nothing, you're saying nothing. I'm trying to take my lord's point and just put it in a slightly different way. But if you were intending to use words that would connote that something else had to be done before the agreement became binding, they have clearly in this very document some rather more clear words that suggest that very thing, namely this agreement will be submitted to Sahara's banking legal partners for validation, my concept of for validation, none of which appears in the second dot on page 47. So I think my lord is really saying, look, in the very document, we've seen the way that parties can express themselves when they want to make it clearer that nothing is to happen, nothing is to be binding, and those are the types of words you'd like to see, but there's nothing of that type in the second dot. I mean,
We have to be slightly, I mean, those words aren't there, so I can't dispute that, my lord, but we have to be slightly careful about how much importance we give to that wording at page 48, because if you look at page 48, it talks about pending legal issues with Sahara's financiers in the last bullet point. It talks about demurrage claims being subject to validation and so on and so forth. So those are specific issues of validation and legal claims that don't bite.
Wait a minute, are you saying that the last dot on page 48 only refers to the preceding four dots?
I think my understanding refers to this, what's called the swap agreement.
Are you saying that it doesn't refer to the whole agreement?
No. That's my understanding. And that, in fact, this is what was given to the banks. If you look at...
Sorry, in which case I have not understood that the suggestion was that wording was limited to what else appears on page 48 and nothing else. I would say, if somebody corrects me,
I hadn't understood that to be part of your case, but
for anybody's case.
The word validation is linked to the demurrage. I mean, I don't understand what's been suggested would be validated. Why would the banks be validating a global compromise, alleged global compromise, of foreign exchange losses and so on and so forth? It's just nonsense. The banks have nothing to do with the foreign exchange losses, for example. So why would they be validating them? And similarly, even though the interest is coming from the banks, there's some interest coming from one bank, some interest coming from another bank. So the idea that this validation relates to the undisputed claims it's never been something that's been factually put that this was taken and validated at a particular date.
But as I understand it, the banks were either had or were threatening to take legal action against Sahara. Was that right?
Yes.
And clearly, if that's the case, Sahara would be interested in ensuring that the banks were content with their settlement if they were going to settle on these terms. Otherwise, they hadn't got the banks off their back, if I can put it that way.
Well, my lord,
Would that be a reason why they would want banks validation?
Well, I just have to caution treading on factual issues. But the banks would have nothing to do with, for example, the largest claim, the Forex claims. Why on earth would they have anything to do with validating that?
Well, if the company Sahara is in financial difficulty, I assume that the banks have either some form of security, and therefore they have an interest in what Sahara realises in relation to its assets, one of which are these claims. I mean, they're not disinterested in what Sahara does with its money.
I can't comment on that. It's not something that it's ever been put.
Well, except, I mean, I thought there were findings to the effect that Sahara was also, I thought we were shown findings that both sides to this document were in financial difficulty of one.
Yes, that is a finding, yes.
Form or another.
That is an agreed finding, yes.
Yeah, so I don't think I'm being terribly revolutionary to suggest that if you're in financial difficulty, and the banks agree with down the net, that if you're about to compromise or settle claims that you have against a third party, you might want to go back to your banks and say, this is what we're going to do. Is it, it would be, I mean, that's, that's why you would go back, presumably, to your banks for, quote, validation. whether it's
yes,
technically, whether,
I mean,
it's
just-
whether it's technically a condition precedent or whether it's just, are you happy with what it's doing?
Yeah, I think yes. I mean, just sticking to Lord Phillips's point of why is the wording validation not used in footnote in resolution 2? And validation is a term used for banks. A company, a government-owned company, doesn't go to the government for validation. I mean, these are specific terms that are picked up from the footnotes under item 5. I mean, you don't have a process of validation.
Forgive me, I
From the
don't think I'm suggesting that necessarily the word validation would have to be used, but
Yes.
what is more generalised, which is parties were capable of putting into this document any requirement as to approval, validation, or whatever of a third party.
Yes, but
So that's the only.
yes, I take your point. I mean, you'll see from the transcript that I put to one of the witnesses, I believe it was Mr. Cole, that he likes simplicity in his business dealings, and asked him, well, why didn't you just have a document saying, Sahara hereby agrees to pay you 76 million. So the point is we have the wording that we have.
Forgive me, but the answer to this is that's probably the prima facie means.
Okay, I take your point, my lord, but I'm just looking at the prima facie meaning of further negotiation.
Just in terms of what was for the court and trial as regards what that may have meant, I think it's the document at page 64 of the trial one, supplemental one. It's the letter of the 19th of September, where Sahara reports that the following meeting, the financial reconciliation documents, as signed by both parties, were submitted to Sahara's banking and their legal partners, as agreed during the meeting for validation, in a bid to halt the severe ongoing legal actions. So certainly that suggests that as far as Sahara were concerned, it related to the whole of the financial reconciliations.
Yes, but if you read the following paragraphs, I mean, I'm not party to what they put to their banks, but if you read the fourth paragraph under that heading, it is very clearly talking about the swap.
Sorry. Are you saying there was no exploration and trial as to the relation, or as to the communications between Sahara and its banks in relation to this agreement?
I have seen, from memory, lots of chases from the banks for the debt that were submitted prior to this meeting, saying, look, we need this money, and so on. I have not seen, it might be in a bundle, but I don't recall seeing anything saying, here, Mr. Bank Manager, here is a joint agreement. This is the closest I've seen to it. And I've certainly not seen any form of validation, so to speak. And this item on my reading is only talking about the swap agreement and what's left over.
Can I just ask you about that? I'm sorry, we're firing lots of questions at you.
That's fine.
It's difficult for you, and you've got other points you want to get onto. But just in relation to that final point, that this agreement wording is confined to the swap, the last bit. That wasn't something the judge found, was it?
No.
And is it anywhere in your skeleton?
My skeleton to the judge or to your lordship?
To this court? I'm not saying
No, it's not.
but
It's not.
I don't
It's not, my
recall
lord. It isn't. I mean, the one thing I would say from the judgment that ask you to look at, and I was going to come back to that, is it's not directly related to your question, but the judge looked at. I'm sure you've seen it, paragraph 132.
Yes, I've got that, and that's
Yeah.
that's not
That's not the
is it?
point.
No,
But the answer is no to your question.
and it's not the subject of a respondent's notice, obviously.
It's not.
So did you always come on page 64?
Yes. Sorry.
Yes, thank you.
If we return to the note, I've taken you in paragraph 6 of the note to the re-examination of Mr. Fadipay. And in his cross-examination, Mr. Mataho, at item 7, I put, so to your understanding, it was important to see what the government of Cameroon had to say about these claims by Scenario LADS. And to your understanding, the government of Cameroon had not yet been presented with the detail of the meeting. Not to my knowledge, not to my knowledge.
I'm not sure how that helps you. His point, it may have been a bad one, is you get the government's view through Sonara, because it's the majority shareholder. Maybe right, maybe wrong about that, but I'm not sure that the answer helps you, does it?
My understanding is it does. Obviously, I don't want to look at the start debating the evidence, my lord, but that's why I said the government of Cameroon had not yet been presented with the detail of the meeting. But the point is, what was the purpose of footnote 2 and the express resolution? So resolution 2 and the express resolution that these matters would be submitted to the government of Cameroon. Why would Sahara be interested in that? Why would it make a resolution to that effect if it had no impact on what the parties were discussing?
I'm not don't mean to be picking you up.
No, that's fine.
But it doesn't say that the matters will be referred. It's the documents that are to be.
Yes.
Documents are collated and submitted to. I think you have to do quite a lot of work with that, don't you? You have to say that that means that they are then required to. It's a requirement that they consider, approve, or otherwise what is in this document, whereas what it is that's been submitted and received is supporting document.
Yes, I agree. If it was just this, it would need a lot of work. But what I'm saying is that this is one of the footnote, one of the resolutions. I need to stop calling it a footnote. It is one of the resolutions that reflects the background, which includes that this is a wholly, I understand, wholly or nearly wholly government-owned entity with no money that needs the government to really support any liability it may undertake. I've got the paragraphs. I'm sorry, I've said it's a speaking note, so I don't want to do the unfair thing of where I just dump it on you. But just in the interest of time, you'll have the some of the transcript records that you can perhaps read at your leisure if you don't mind.
Yes, we will.
And then I'll just look at the so I'll let you read those. And then what I say, item 11, a submission to the government was needed for the government to agree to pay. Sonara would have no reason to agree a liability in the meeting if the paying party, the government, had not agreed to release the corresponding funds to meet such a liability. This is a key point why in Resolution 4 there is an express resolution for further negotiations on the undisputed claims. And the point about item 2 is there would be no need for a resolution on what Sonara would submit to the government if liability for these claims had been agreed. I then look at Resolution 3, just for completeness, and then Resolution 4, which is really what Her Ladyship found was a key obstacle to finding a settlement. So we've got Sonara will communicate a date within 2 weeks for parties to reconvene. So if we just look at the document page. I believe page 47. So I'm just quite careful because I think in the claimant's skeleton by mistake there's a full stop where there should be a comma after reconvene. Sonara will communicate a date within 2 weeks for parties to reconvene, comma, Sonara to propose potential flexible payment terms, schedule, and further negotiation on these undisputed claims. So the first point is a resolution that the parties will reconvene emphasises that there are matters to further negotiate. Obviously, it doesn't seem like there's going to be any negotiation on the disputed claims given Resolution 3. It's been rejected. So the obvious candidate for negotiation just from the reconvening is the undisputed claims. And then the point is the proposing of potential flexible payment terms, and this is what was argued, and I think is still argued in the appellant skeleton is that the reference to potential flexible payment terms must only be to the undisputed claims, because I think a phraseology was used that the sums in item 1 and 2 are in Sonaro's accounts. Now that's not evidence, that doesn't accord with the evidential record, and I'll come to that in a minute. Actually, I can go to that. Bear with me. Just bear with me. I thought I'd put the quote in. Just bear with me one moment. So I'll have to take you to the transcript. It's a supplemental tab 14. Sorry to take you to supplemental bundle tab 14. Page. Page 140, sorry. This is the cross-examination of Mr. Cole. So I'll just wait for you to get to page 140, my lord. It's at internal 179, transcript page 179. Mr. Cole was asked, and this is line 24, and then at page 264 you'll see the reconciled claims, yes? Yes, my lady, I see it. So there's no date in this document for the payment of table 1 and 2, is there? No, my lady, there's no dates. And that was something Sonaro had to propose, correct?
I'm very sorry, it's me. 114.
140, I'm sorry, my lord.
Was it? Sorry, I
Okay.
misheard you. Sorry.
For some reason I thought I'd spoken this in the note. I'll wait for you to get there, my lord. Oh, gosh. So I'm looking at, sorry, it is in my note. It's at paragraph 22. It's a panic attack. Paragraph 22. But you can read it there as well. So once you've read that, my lord, if we go back to paragraph 14, so the point is, it was seemed to be common ground, but it certainly is clear from the document itself that there is no date agreed for payment of items 1 and 2. So when resolution 4 talks about proposing potential flexible payment terms, that would include payment terms for the items in tables 1 and 2, and if table 3 is agreed for that as well. And then we have the strongest point, so payment terms and schedule. And then we have the strongest point, further negotiations on the undisputed claims. This is not limited, as the appellant asks you to read it, to further negotiations only on flexible payment terms. I mean, that defeats the purpose of the word further.
I thought Mr. Young accepted that. I thought he said that it was possible that after Sonara had sent papers to the government of Cameroon, there might be further negotiations as to the undisputed amounts. He accepted that concern. And I still do.
I'm struggling to understand how it can be argued there was an agreement of something that was open to further negotiations.
I think he was saying that it was it was agreed that they were undisputed, but that didn't stop a party coming back and saying, but we've got difficulty paying this, so we'd like, for instance, to have a reduction or to have an extended period to repay. I think that's the point he was making.
But my lord, that is a roundabout way of saying you can only have negotiations on the time for payment. Because either you can have further negotiations, which would include
It was quite clear that he accepted that they might come back and say, we want to pay less. You might have a field day with that. I can see that.
if that's being suggested, then clearly if you haven't even accepted what your liability is, you could pay less, then how can there possibly be an agreement? I mean, I'm not sure why.
Well, I think Mr. Young says that would involve a renegotiation of an existing agreement.
Well, then, sorry, if you're expressly leaving out the possibility, the agreement, the resolution that there will be further negotiations, that is not a renegotiation. Agreement doesn't say we're going to meet for further negotiations on anything. I mean, that was the point the judge said, and one that I very strongly agree with. You can't say, well, because I've got a headline undisputed, and then I've got the words from a insolvent government company saying further negotiations. How can you possibly say with a straight face this is an agreement for $70 million or any sum? If my learned friend is accepted that the only point he made on this previously, as I understood, is that you must read into further negotiations that these are restricted to flexible payment terms and schedule, timing.
I'm not sure whether he's abandoned it, but he certainly recognises that it may be wider than that.
Yeah. Well, if it's wider than that, then it's not. I mean, I don't see. If you say that this item is subject to further negotiation, to then say no, we're actually saying everything is agreed. Well, what you could apply to amend it, and that's not the wording they used. And that Ms. Nassau spent a long time on the stand saying that the comfort that Sonara got from these words, these specific words that I'm taking you to, outweighed any alarm about the headline undisputed. So what? Sorry, I might sound really because I hadn't appreciated that was said yesterday, and that's my fault. And I'm grateful to you.
Well, certainly, it's certainly an acceptance which, to some extent, shifts the dial in your favour.
Well, I would say it
How
makes.
far it shifts it is obviously what you may wish.
Yes, well, I would say that it just makes it inarguable that there was an acceptance of liability, because this is a classic case of no acceptance. It's an agreement to agree, and that is why the judge, who was, I think, quite unfairly said to have gone off the rails yesterday. I mean, if you're accepting that the further negotiations are unlimited, then in my submission, you don't have a leg to stand on to say, yes, but there is still a binding agreement and you owe me $70 million. And I would add this, your lordships are rightly, as was her ladyship, troubled by the headline undisputed claims. But what I would emphasise is, firstly, this is a resolution that the parties have gone out of their way to explain. It's not just a headline. It is backed up, I think, to some extent by resolution 2. But what the point is when they say further negotiations, they say specifically, to avoid any doubt, on the undisputed claims, they adopt the nomenclature in the headline to say, well, whatever this is, we're still going to have further negotiations on it.
They're going to have negotiations, aren't they, in relation to time and schedule of payment, in relation to all the items. I think that's the point you make in paragraph 20 of your speaking.
They're going to have that for sure, because that has to be proposed.
So why can't undisputed items mean those items which are not disputed, categories 1, 2 and 3? If they are all in fact going to be subject to negotiation in terms of schedule of payment.
That is a perceivable idea, but I think that undisputed, they've so faithfully copied the headline of Table 3 that unless it's been suggested that this is I think it would be
well, it's a question of whether they're using undisputed items as a defined term, or to mean what it's set against you is its natural meaning.
Yeah, but I think it would be a vandalism.
That are not in dispute.
I'd take that. I mean, that could be argued, but I think it would be a vandalism of the language to say that when you have a headline, undisputed claims, copied word for word in the resolution, that is talking about something other than what's in Table 3.
So what you say, paragraph 20, is that they'd agreed that we're going to be further negotiations about the timing of payments for items 1 and 2 isn't the subject matter of any express agreement about negotiations. It's just the fact that it hadn't yet been agreed.
Yes. However, obviously, if during the further negotiations on the Table 3 claims, the undisputed claims, there were an acceptance of liability, which I say hasn't happened yet, then there would also need to be a proposal of when those would be paid. So what I'm saying is that when you look at Resolution 4, the potential flexible payment terms and schedules certainly include Table 1 and 2. And they could also include, depending on the further negotiations, Table 3.
Well, probably not on the timing, because they've got to do their proposing within 2 weeks, haven't they? So if negotiations means trying to agree for the first time whether the Category 3 undisputed claims are payable or not, I'm not sure that's going to come within the proposal envisaged by the first half of the clause.
I take your point, my lord. I think that there is some confusion as to what's meant to happen in 2 weeks. I don't think it's apposite, it's particularly material to what my case is, but I take your point. But the main point is if, and I think my learned friend has kindly confirmed that, if it's accepted that it's no longer being suggested that further negotiations are limited to flexible payment terms on Table 3, which I think is rightly withdrawn because that's just not credible on the wording of the document, then I say that it is an untenable argument that further that there could be a resolution that there could be further negotiation on the undisputed claims, amount, etc., with no limitation, but somehow there was still an agreement reached in this document on those claims. There is another point that I have raised in my note, and there's something I may put to her ladyship, which is that if, I mean, it's no longer really an issue, but if all that the parties had left over for negotiation was the time for payment, I say that was an objectively essential term because we have as a factual finding.
So I thought you'd accepted earlier that there was a binding agreement, that the judge had found there was a binding agreement in relation to items 1 and 2.
Yes.
And there hadn't been any agreement as to date of or timing of payment in relation to those.
Yes, but
so how does that sit with this submission that not having agreed timing or date of payment is fatal to a concluded agreement?
Well, let's taking that in stages. Firstly, I haven't taken issue with the judge's finding on that 1 and 2 because it's no longer an issue. So I don't necessarily argue that it sits well with it. But if you ask me, can I see a distinction between those two things? I think there could be a distinction in that for item 1 and 2, because they were contractually due rather than damages claims, it's easier to find a timing for payment or the interest keeps accruing, I guess. But for the damages claims, which are a global settlement, the idea that it was not essential to the parties objectively, the timing for payment, I think is wrong. Because
because these are sums which have been due for a very long time. When they're due is now, or a payment schedule would be effectively Sahara agreeing by way of concession that they can be paid over time rather than immediately commencing proceedings.
But if we pause there, this is not a situation where the parties are silent on time for payment. This is a different situation where the parties have expressly and positively left over for negotiation time and schedule for payment. So they have obviously left over for negotiation an objectively essential item for both of them. Sahara really needs the money pronto. Sahara has no money. The idea that this was a minor issue that had been left over for further negotiation, I say, is wrong. Objectively, as a matter of construction, and in light of the agreed commercial background, I don't think this is necessarily a point alive anymore because of my learned friend's concession. If the only negotiation left was about when you will pay us, I say that is sufficiently essential to prevent an agreement arising on the undisputed claims.
If liability is disputed, agreement that there is liability even if you don't agree on payment schedule, is an extremely valuable matter, and one which is perfectly capable of forming a binding agreement.
Well, I think that's the difference between that is stretching the meaning, the natural meaning of the word undisputed. Undisputed could mean, at its highest, I say, that in this settlement we're not going to dispute, for the purposes of this settlement agreement, we're not going to dispute. It's not saying I hereby admit that I have a legal liability to pay this. So I think there is a difference between admitting an admission of liability, which could be useful. I think that's the point of difference. Well,
Just before we
yes,
make one other thing, it was pointed out during the argument yesterday that the judge in paragraph 136 had just slightly misquoted point 4 resolution, which he used capital U and capital C. Do you accept that that may mean that she may not have focused on the fact that my lord's point that undisputed claims might not be limited to 3?
In my submission, no. I think that I certainly don't remember we all received the draft judgment. I don't remember someone writing and saying, you might have made an error here. That's the kind of thing that council would pick up. Unfortunately, was not instructed at that time for various reasons.
But anyway, you say.
But I said this is a usual type.
It doesn't matter because she was right. You say to treat small u, small c undisputed claims as essentially being a defined term, namely the headings of category 3.
Yes, I mean defined term. It wasn't a defined term, but it was a headline for table 3. So therefore, she was talking about table 3.
Used as if it were a defined term. Yeah. We must let you get on. We've been interrupting a lot, and I know you've got a fair bit to cover, and we've got Mr. Young a little time to reply.
My lord, I do have a fair bit to cover on ground one, but I think the point we've just discussed about the admission that the further negotiations are not limited to discussing payment terms, I think just means that I don't really need to spend much time.
I don't understand Mr. Young to have made that admission. So, have you made that admission, Mr. Young?
My lord, no.
No, all right. I thought not. Don't worry.
No.
We can come back to you.
Yes.
In reply as need be. So, Mr. Hussain, I wanted to clarify that because I didn't want you to feel you've been misled into not saying something you wanted to say.
Okay, no, that's really helpful and very fair, my lord. But then, if we go back to my note, which sets out at page 4 the resolution for my learned friend's argument, as I understood it, was well, the reference to proposing potential flexible payment terms and schedule can only apply to the table 3 claims, the undisputed claims, and therefore. The wording further negotiations must relate to just those things. I mean, that's wrong in 2 respects. The potential flexible payment terms and schedule also apply to the table 1 and 2 claims. That is obvious on the face of the document, and Mr. Cole also accepted that. My learned friend tries to make a factual argument that was not accepted by the judge. I don't even recall it being put that somehow these were in the account of that somehow these were already in Sahara's accounts. I don't understand that. There was a net payment due under tables 1 and 2 after the swap. and it would need to have a timing for payment. That's the first point. But even if he's right that the potential flexible payment terms and schedule only apply to the undisputed claims, the Table 3 claims, that still doesn't get rid of the word "and" or the word "further." And the point that Ms. Nassau, again, I don't want to lapse into the evidence, but the point that the judge took was that this and further negotiations on the undisputed claims, repeating the headline, was just a fatal obstacle to a finding that there had been a settlement. If my learned friend has some different limitation to the further negotiations, I don't want to start replying, but I think that's as far as I can take it.
Can I just?
Of course.
It's important to go over this, but can I just put one thought to you for your comment right out of your speaking note? Right at the start of your speaking note, in relation to Resolution 1, you say there were no supporting documents for the principal contractual interest, that is, items 1 and 2 in the report, correct?
I think I mean wider than that, not just in the report. There weren't any handed over.
There are no. That's
Yes.
There are no supporting documents for the principal or contractual interest. So it follows, doesn't it, that in Resolution 1 it says all relevant supporting documents for the claims have been submitted by Sahara, duly acknowledged by Sahara. Those would be, sorry, two things follow. The first is that in relation to the outstanding principal and the interest, contractual interest, everybody knew what those amounts were because it's just a matter of mathematical calculation. In fact, and it is the case that they wouldn't have been admitted on your case unless the government of Cameroon was happy and aware of it and were going to fund it. So there was no sort of need to do anything in relation to those claims. So when Resolution 1 talks about supporting documents, it can only be talking about supporting documents in relation to Category 3. Let's call it Category 3 for now. That's what Sahara would be reviewing and collating and submitting to the government of Cameroon. We know that item 4 claims are penal charges are completely out of order as far as Sahara is concerned, because that's what the third doc says. And so when you look at the fourth doc, why isn't it really just saying that if these claims are now undisputed, or because they are now undisputed, they've been put into the undisputed claims category, but the government of Cameroon won't have seen the supporting documents. It'll be taken by surprise by it, and the negotiations of flexible payment terms, schedules and further negotiations are really only going to relate to those Category 3 claims, because for the first time the supporting documentation has been provided and they're not capable of simple mathematical computation like items 1 and items 2. So that in effect what is being said is that that fourth doc really should read Sahara to propose payment, potential flexible payment terms, schedule and further negotiations on payment of the undisputed claims, i.e. they are undisputed, liabilities admitted, but the negotiations are going to be about time for payment, because it will be the first time that the government of Cameroon will have basically had the chance to look at the documents in relation to them and not been faced with something that just isn't principal and interest, which is capable of mathematical calculation. Is that a...
I think your postulation is really straying outside just constraining the document, obviously making a lot of observations on what the government knew or didn't know.
Actually, I'm only looking at your speaking note and the document. I'm not looking at anything else.
But I think that the point is this. I think it would be the violence on this document to say, and further negotiations on the undisputed claims reads as further negotiations on the payment of the undisputed claims.
Of course I'm doing. Of course I'm
Which-
doing. Hang on. Sorry.
Yeah,
Just
yeah.
something about.
But I'm just making a counterpoint to an argument that may be put against me. I'm not suggesting.
I mean, on any view, violence has to be done to the words of this document.
Yes.
Because you want us to read undisputed to mean disputed.
Yeah, not necessarily, but okay. Because the judge came up with a different reading of undisputed, which is the quantum is not disputed.
Okay. All right. You say more limited violence, or you say no violence at all. Okay. But I mean, the way we look at it at the moment is that you've got a not immediately obvious reading of the word undisputed.
Mm-hmm.
And then on their side, they invite us, at least I thought we were being invited until I heard the debate a little earlier this afternoon, at least on one view, to insert the words in negotiations on payment of, or the time for payment of the undisputed claims. So on any view, there needs to be some...
But I mean, what I would say to that, if that argument, is that is, why would you have Sahara to propose potential flexible payment terms, schedule, and further negotiations on payment? That makes absolutely no sense. That is, it's got to be something other than payment and further to payment. And the point is, if they wish to, as a party that is now seeking to rely on this document, they wish to limit the negotiations.
But I think on your case, coupled with the judge's case, negotiations is not unlimited. It can only be negotiations as to liability for the Class 3 payments, not negotiations as to quantum, which in the judge's case was what's meant by undisputed.
Well, I'm not
So
sure it
one's
goes
got,
that.
one's
I
got
think,
to do some qualifying with
no, the judge
negotiation
said.
in your case.
Sorry, my lord. I think that is taking it too far. The judge said the meaning. She tried to find meaning in the word undisputed, which, in my submission, you don't need to, or neither did she. She just needed to see whether she was satisfied on construction that these claims have been compromised or not. But when she gave it meaning, she said it means that the quantum is not disputed. That doesn't mean that the quantum is now bindingly agreed, because obviously there is no agreement overall. When there is no agreement overall, whether you call one aspect of it undisputed or not, there's no binding agreement to bite. That makes sense. So I think we need, the danger in the appellant's argument is that it fixates on the meaning of the headline undisputed and moves the court away from the question, has there been an agreement to pay these claims? And you can't let the tail wag the dog. You can't say, well, because I can't find a meaning of the word undisputed, I'm going to find that it was agreed. Even though the wording is pointing to whatever these undisputed claims are, we know what they are, they're forex claims and incremental interest claims, they are going to be the subject of further open-ended negotiation.
I'm sorry, we're interrupting.
No,
you
no,
too
it's
much.
very helpful actually.
I want to make sure that you've got enough time to deal
Yes.
with limitation.
I'm going to ask your lordships to read then paragraphs 141 and 142 at your leisure when the judge looked at what undisputed could mean. But please bear in mind my submission that that is not the question that she was required to answer. I would like to hand up, if I may, a case that I sent my learned friend this morning. I'm just going to. There was just one paragraph in it that I thought was quite helpful. Not necessarily to my case or my learned friend's case, but just to the exercise we are undertaking. If I can. And I apologise for the late authority. My lord, I'll explain to you what it refers to. Thank you so much. It's the, I'll let you get it. It's the judgment of the Court of Appeal in a case called Barbadev and Eurocom. And it really put into words, I think, something that the court was trying to elicit, and I wasn't express them very well. It's paragraphs 37 and 38 of the judgment of Lord Justice Aikens. When he talks about the intention to create legal relations, in paragraph 37 he agrees with the judge at first instance that the document before him did create legal relations. I'm just refer your lordships to paragraph 38. Again, this is uncontroversial. It's just articulating.
He disagreed. He said Mr. Justice Cockerill was wrong on that. Sorry, you said agree.
Oh yeah, sorry, disagreed. He found that there was a intention to create legal relations, but then he says, paragraph 38, but that conclusion does not necessarily assist Mr. Barbadev. The parties can have intended to create legal relations between themselves, but it does not follow that the effect of the side letter is that it created a legally enforceable contract giving Mr. Barbadev the right to purchase a 10% stake in the new merged business for 1.65 million. The court has to go on to examine the nature of the legal relations that were actually created. And then he says, to take an obvious example, two parties may orally agree to sell and purchase some land, and in doing so may well have intended to create legal relations, but such a contract would be unenforceable in the absence of an agreement in writing. So the court has to analyse carefully the nature of any agreement which the parties have reached, at least ostensibly, in order to see whether it constitutes an enforceable contract. It's a simple point. I don't think I'm getting pushback on it. It was that the judge was entitled, as she did, to find that the joint report creates a legal agreement, and at the same time find that the particular items in Table 3 were not agreed. There is a point of criticism of the judgment, paragraph 132. Page 116, I'm sorry. And this is what my learned friend calls a panion point. I think this is a criticism, is a mischaracterization of the judgment. It's suggested that the judge somehow failed to give due regard to panion because it suggested she found that if some items remained disagreed, then nothing could have been agreed. That's not what she said. She said, this is the third line from the top of paragraph 132, the submission that the reference to this agreement in the very final bullet point is determinative because there's no language confining it to parts of the joint report cannot stand. And then she goes on to explain. But the point she was making was in my submission, an uncontroversial one. Yes, the bullet point I think that Lord Justice Phillips took me to after the swap agreement does refer to an agreement, but that is not determinative of the issue whether the Table 3 claims have been agreed. That is the highest she took it. She didn't say anything contrary in my submission to the findings in Panion, which are that depending on the objective facts of the case, the parties can have an agreement without everything being agreed.
The judge certainly didn't confine that wording. This agreement will be submitted as far as banking and legal parts for validation. That's what she's talking about, is it? She certainly didn't confine that simply to the swap agreement.
There's no way in hell where she does that. You're correct. I've not seen that.
Yep.
My lord, if I can then, I'm just conscious of the time, move on to ground 2. So the ground, if we look at the core bundle, tab 1, at page 15. The judge erred in finding that Sahara's claims for Roman 1, Sahara's claims for the undisputed sums were not claims for a debt or liquidated pecuniary claim within the meaning of section 29.5, and Roman 2, the joint report, did not constitute an acknowledgement of those claims. Just taking that in the two stages, you will have in my skeleton, my lord, so the first point is section 29.5 has a dual requirement, both have to be satisfied. The claim has to be for a debt or liquidated pecuniary claim, and then there has to be a acknowledgement of that liquidated pecuniary claim. And in my submission, neither of those are met. you'll have in my skeleton the references to the pleading, but the pleading pleads each item as a claim for damages for breach of contract. The breach of contract in each case being the failure to make payment on time. So the incremental interest, the foreign exchange losses and so on, and the penal charges are each claimed as damages for breach of contract. And the authorities are clear in my submission when looking at section 29.5 that claims for damages for breach of contract that are not liquidated damages under the contract do not qualify under section 29.5, even if they're very easy to ascertain. So the first authority, I'm not going to take you to each one, but if we go to the authorities bundle tab 11, I'm scared to pronounce this Welsh authority, Mr Justice Jackson. Welsh water, I'll call it. Got, Well Cymru. With apologies to all Welsh people. So we're looking at page 143 from Mr Justice Jackson. I'm looking at 49, item 3. The global phrase, any debt or other liquidated pecuniary claim, suggests a sum which is due to be paid pursuant to some contractual or similar obligation. The words and their natural meaning do not connote damages or compensation which the law requires to be paid by someone who has acted in breach of an obligation or duty. And similarly, specifically on contractual damages, we have the judgment in Jarvis and Harris, which is at tab 7, page 85 of the bundle, from Lord Justice Millett. At 85F through to B on the next page, Lord Justice Millett says the law of contract draws a clear distinction between a claim for payment of debt and a claim for damages for breach of contract. He refers to Chitty. As they're stated, a debt is a definite sum of money fixed by the agreement of the parties, whereas damages may be claimed from a party who has broken his primary contractual obligation. And then goes on to explain the difference. One of the points being you don't need to prove your loss, which obviously, hey, you do. So I've got some other cases in the skeleton I'm not going to trouble you with, but I say that this argument really doesn't get off the ground. It is clear it is a claim for damages for breach of contract. The fact that it is said to be easy to ascertain doesn't help as far as the Act is concerned. And I've also given the reference to Barnett and Craigie. That's in my skeleton, my lord, which makes the point that just because something is easy to ascertain doesn't bring it into the ambit of section 29.5. In terms of the acknowledgement, again, I don't think I need to add to my skeleton. I think it's quite clear that unless the acknowledgement has to be of a legal liability and the indebtedness, and if the appellant fails on ground 1, then there is no admission of liability. Moving on to ground 3, if we go back to the core bundle, my lord, at tab 1, page 15. The judge erred in finding that as a matter of construction, clause 26 of the contract was a specific indemnity aimed at losses arising from the exercising of remedies under that clause rather than a general indemnity. And Roman 2, the limitation period in respect of losses recoverable under clause 26 ran from the date of the first loss recoverable thereunder rather than commencing separately in respect of each loss from the time at which each loss was sustained. The argument as developed on Roman 2 in the skeleton and by Mr. Du yesterday was that it's being suggested that there is a separate loss for each day that interest is charged, and therefore the time starts running afresh.
Because that's when the loss is incurred. That's what he says
Yes.
about interest. It's not. I don't think that's a different point. It's just he says that's how the argument works in relation to interest.
So you have my submissions as skeleton, my lord. I'm going to expand on them somewhat now. I say that the ground of appeal fails on both points. The first point that was taken was that this was a general indemnity. Clause 26 created a general indemnity in the terms suggested by the appellant. But yesterday there was a statement inconsistent with that when it was said it's not being suggested that the alleged indemnity overrides clause 18 or indeed any other clause that limits recovery in any way. I mean, it's simply, they have to argue that to make the point good. If it is a general indemnity that applies to every event of default, then it must be on the terms of that indemnity.
I'm not sure that follows. They're perfectly entitled to say, aren't they? This is what this indemnity means, but it's only one of the clauses. And if one's construing the agreement as a whole, where you've got a specific clause which deals with a measure of loss for particular circumstances, the parties must have intended that clause to apply in those particular circumstances.
I think
that I understand is the nature of the qualification. I may be right, may be wrong.
I'll deal with it.
But it is coherent anyway.
Well, no, Massimo, I probably need to take you to the documents in a moment, but it isn't because clause 18 applies to every claim for damages. So it might be that I need to kind of run you through my argument, whether it's right or wrong. I want to start with the judgment in the Euros case, which talks about...
So you're saying even if on its face clause 26 is a general indemnity, as general as it could lawfully be, it must be subject to the other specific clause, any specific clauses in the contract providing for damages, and you say there is one which actually completely ousts clause 26.
I think it's rather the other way around. The judge said, in order for the indemnity to exist as is being alleged, and that was the position taken because they were facing a remoteness argument, clause 18 would be rendered OTOs, as would clause 8, because they would just simply get their actual losses no matter how remote.
Well, that's not the argument now. I mean,
yes, but
we do
in order to make
on what the rival constructions are in this court.
Yeah, I think my point is it's not they've changed a position point. That would be quite a silly point to make. My point is to make the argument good, they have to necessarily argue that it overrides 18, and I'll show you that when I look at the contract. The starting distinction is between what Lord Justice Stoughton in the Euros called as the two possible meanings of the word indemnity. I want to look at that. So if we go to the total transport case, which is in the authorities bundle.
I just understand where you're going with this. Do you say that indemnity in this case is limited in the way Mr. Justice Stoughton limited it in the Euros? That is to say, it doesn't give a greater right than the right you would have if it were a normal contractual claim for damages.
That remains my primary position as it was at first instance, or it is limited as the judge says.
Pause for a moment. That is also the appellant's case. So do we need to look at the Euros?
No, sorry. The Euros, it might be that we are rushing. Let me just go there, my lord. I'll still be in time, and I've told my... I'm so sorry. I'm mortified, I apologise. I promised my learned friend time to reply, and I'll be within that time. I just don't want to rush this.
No, take your own course.
If we can go to tab 9, I apologise, my lord. Lapse in my fault. And we go to page 114. I'm looking at Lord Justice Stoughton's judgment. Thank you for...
He's right, but
Okay.
I think we'd all.
I apologise for my
dictionary. I think we'd all done the translation in our heads. So don't
I'm
worry.
sorry, he was my extended chamber, so I sort of figure out that.
Apologies, my lord. I haven't got the diction of public school boys, but I'll try my best. Page
Some of us
114.
don't either. Not all of us do.
No, indeed.
Indeed, that may be regarded as an advantage, so don't worry about it.
Thank you. So just short in time, so trying my best. So he says, paragraph page 114, there's a risk of confusion in this field if one does not define one's terms. And he talks about remoteness. And then he says, over the page, the word indemnity is likewise used in two senses. It may mean simply damages for tort or breach of contract. Alternatively, he carries on, the word indemnity may refer to all loss suffered which is attributable to a specified cause, whether or not it was in the reasonable contemplation of the parties. There is precious little authority to support such a meaning, but I do not doubt that the word is often used in that sense. And then he goes on to say which one of these, whether it's just simply repeating the right to damages or whether it's creating an additional right, is a matter of construction. Now, the point put was, if we go to clause 26, which is in, bear with me. Page 34 of the supplementary bundle, tab 3. And I'm going to come to the syntax of this, and Mr. did helpfully take you through that syntax. But if we go to page 30, so we see events of default termination clause, that is the actual context. This is a termination clause. And then if we go over the page, if your lordships were there yesterday, you'll see the items A, B, C, and D, and then they follow 5 paragraphs, which I've numbered just for reference. It might be helpful if you number them 1, 2, 3, 4, and 5. So what is being suggested is that by sub paragraph 4 in the termination clause, a general indemnity is created, which says the buyer shall indemnify and hold the seller harmless from all losses, damages, costs, and expenses, including legal fees that the seller would not have incurred, but for the event of default and or the exercise by the seller of any of its remedies hereunder. Now, what was said was that this must mean something more than just repeating the right to damages for breach of contract, because otherwise the words would be surplus. And my submission is no, it doesn't necessarily follow that just because the word indemnity is used, that it's anything more than surplusage.
It clearly does confer some rights which are greater than those for breach of contract, because it provides for this indemnity to be triggered by certain things that aren't breaches of contract.
Yes.
Not relevant necessarily to the dispute we're concerned with.
Yes.
But,
yes.
But I thought it was accepted on the appellant side that insofar as it does cover breaches of contract, it is an indemnity in the sense that Mr. Justice Staunton referred to in the Eurus. That is to say, it doesn't cover all consequences, it only covers those within the reasonable contemplation of the party.
But yes, but it's not just, I mean, in that case, in the Eurus, they were dealing with remoteness, so that was a live issue. It's no longer a live issue here. But the live issue here is this indemnity, so is this sentence, this sub-paragraph, creating something extra, something beyond what would be a right to damages in any case, because otherwise you would be stuck with the usual Section 5 Limitation Act cause of action, which would be on the breach. You're stuck with your cause of action starts on the breach. So the appellant has to argue in the first instance that this sub-paragraph creates something that changes the cause of action from the usual cause of action, which is the dateful cause of action from breach, to the loss. Now, the only way that they can do that is by saying that it creates an indemnity in the second sense. But if it created an indemnity in the second sense, it would have to be an indemnity to hold the seller harmless from all losses, damages, costs, and expenses, including legal fees, that the seller would not have incurred but for the event of default, which includes any non-compliance, however big or small, and or the exercise by the seller of any of its remedies hereunder. So in order to argue that it has that meaning, it is not possible to then say, well, but however, if we go back 4 pages, to item 18, it is subject to item 18. But then it's not an indemnity. What is it actually doing other than repeating the right to damages for breach of contract? If the point of difference, as your lordship has identified, which is an appealing one, if the point of difference or the point of addition of this clause at page 35, this sub-paragraph, is that it can operate other than a breach, because the events of default at item, go back a page, the events of default at item E, F, G are not breaches of contract, then that marries with the judge's finding that if this is an indemnity that only bites if a termination notice is given.
If a termination notice is given, because it's confined to remedies.
Yes.
Yeah, my understanding of your argument on this is that if we look at page 35, we go to the top of it, and the first, you get to the end of the definitions of event of default, just after H. Right? So we then sort of draw a line, if you like. That's just a definitional part. And then, beginning upon the occurrence of an event of default, or an event default, there are a series of things. If an event of default's occurred and notification or in writing, a number of things can happen, or steps can be taken, by the seller. And they're set out A, B, C, D. And then my understanding is, you say, what this clause is doing is in the unnumbered, indented clauses 1, 2, 3, 4, 5, as you tell us to number them, exactly what you should do. There are certain consequential matters, but they're all governed by the opening, the non-indented bit. There has to be an event of default and notification.
Yes.
And they're just consequential.
Yes.
First it says it continues whether or not the early termination occurs, whether or not the event of default is then continuing. Then the seller is given certain specific rights in number 2. There are certain further provisions in relation to B in the 3rd paragraph, and then in the 4th, it's an indemnity limited to the designated items that the seller would not have incurred but for the event of default and or the exercise of the seller of its remedies hereunder, namely the ones which have been set out further above.
Yes.
And the reason for the and or is because you don't want to have a funny argument that there's a sequence of events here, an event of default plus the giving of notification, and what you don't want to have is a funny argument that indemnity doesn't apply to something which, for example, only related to the event of default, but not to the giving of the not to the exercise of any of the remedies on.
Yes.
You're saying this is all within a narrow compass.
Yes.
And that's why it doesn't amount to a general freestanding indemnity, which you say would in any event cut across clauses 8 and 18.
Yes. So it is.
I've got your argument.
That's perfectly articulating the point. It is in the termination clause. It is then indented into a slipstream in that termination clause. It is then a sub paragraph 1 of 5. That is not the place where the parties would expect to put a general indemnity for every possible breach. And if the argument, I think the highest argument put was, well, you would then have some trouble with the words and/or, but that trouble in my submission is far less disruptive to the contract as a whole than a finding that there is a general indemnity that cuts across clause 18 and clause 8 and so on.
Yeah, and I think you say the and/or is really designed to cater for some funny attempt to limit this particular indemnity, to say, oh, well, those fees were only incurred in relation to the exercise of the remedy, they weren't incurred in relation to the event of default, or vice versa.
Yes.
You say it's all within the scope of this clause.
Yes.
And it doesn't amount to a general indemnity which would cut across the other clauses. I mean,
Yes.
That's really right or wrong, isn't it?
Yes, my lord, that is.
And the judge said that. And you go to the result.
Yes, happily, yes.
So as it comes below A to D, and it refers to the exercise by the seller of any of its remedies, how could one interpret that as relating only to when there's been termination?
So it's more upon the occurrence of an event of default and after notification of to the buyer in writing. There's common ground that no such notice was given under this clause.
You say hereunder means under this clause starting with the word upon the occurrence.
Yes.
Just like in the next paragraph, it says the provisions of this clause and the seller's rights hereunder. I mean, that plainly means seller's rights under this clause. And you say, well, hereunder, when it appears in paragraph 4, means the same.
And then obviously there's an indent of what they might do, notify the buyer, and then we see the further indents if that further notice is given. So there's notice of default, then the notice of various things, and then we start seeing those 5 paragraphs.
Do you say that the indemnity can only ever have any operation if the seller does purport to exercise some of its remedies hereunder? So if you have one of those events of default that isn't used to trigger early termination, but does give rise to some loss, you say that's outside the scope of this indemnity, do you?
No, this is my secondary point, but no, on that, they would still need to give the notice that's above A.
I'm not sure the answer to my lord's question. I think, can my lord put his question again? Because I'm not sure. I was very surprised by that answer, but I'm not sure I followed the question and the answer.
The cases that put against you is you have got 2 halves to this indemnity. One is for losses which wouldn't have been incurred but for event of default, and the other is wouldn't have been incurred but for the exercise by the seller of any of its remedies hereunder. And your case, as I understand it, is that and/or means and.
Yes.
And that there is no room for an indemnity merely for losses in the on the occurrence of an event of default.
Yes, that's correct.
Unless there is also an exercise by the seller of remedies. But if there is an exercise by the seller of remedies, then you can get the losses which are solely attributable to the event of default, not to the exercise of the remedies. Have I understood your case correctly?
I haven't gone that far to consider the hypothesis. I'm just saying that both of them, the and/or is an and. But
well, I think that is the effect of and, isn't it?
Yeah.
Because if it means and, you've got to have the exercise of the remedies to trigger the indemnity in the first place. But you are then, if it genuinely means and, entitled to recover for losses flowing from the event of default.
Yes. Well, that's the point of whether the indemnity covers the claims being put, and I say it doesn't. But if it did, in terms of when time starts running, if we can look at the judgment at tab 9, page 130. There's paragraph 204 onwards of the judge's findings and exposition of the case law that I adopt. It says in paragraph 204, the starting point is a basic rule that the right of action in contract accrues as soon as there is a breach of contract. It follows that for a claim under an express indemnity, the extent of the indemnity and the time at which the cause of action arises will depend on the construction of the contract. This is common ground between the parties. Here it is said that as a matter of construction, said by Sahara, each time that Sahara incurred a loss, whether by the imposition of default charges or the incurring of further interest, there was a separate breach of clause 26 by Sahara not indemnifying Sahara, with the result that on each occasion a separate cause of action accrued under clause 26 and a separate limitation period began in respect of that particular loss. And I concur with the judge that that is an artificial distinction. The breach remained the same. The breach was the failure to make payment on time, and if there was an indemnity, which we say there wasn't, but if there was an indemnity to make good the consequences of that breach, that indemnity was also breached from day one. It wasn't breached separately each day.
So it was a breach to fail to indemnify against a loss which hadn't yet occurred.
Yes, and
that is your case, isn't it?
yes, because the way you would indemnify is by paying the money,
What money? How would you know what on earth to pay if the loss
Not
hasn't even
pay-
been
sorry.
incurred yet?
paying the principal debt on time. That would stop the interest arising.
That's not the breach that's being sued on. That's looking at it as though it's a claim under clause 8. It isn't. It's a claim under clause 26. If we get here, it's because there is a claim under clause 26.
Okay,
There isn't.
yeah, I'll take your point. But the stronger point then is the difference in the losses. So if we look at paragraph 206, the judge says Sahara meets instinctive revulsion against such an analysis by citation from contractual indemnities. She quotes, multiple losses assume that there are several consecutive and distinct losses, all of which are within the scope of the indemnity. An issue that's occasionally arisen is whether there is one breach of the indemnity with several losses, or several breaches of the indemnity, each breach corresponding to the occurrence of a loss. The latter view is correct, at least where each loss is discrete. And the judge found, and I submit rightly, that there is not a discrete or separate category of loss for every day that interest accrues on a unsatisfied payment.
Where do we see that reason?
So she looks at
Is it 214?
yeah, so she goes through each of the cases, and then 213, she says, this is not a case like Wiseman where there are truly separate breaches and separate losses, and indeed this line of argument was not pursued orally, nor is this a case like the Caroline P, where there was essentially no liability until judgment in the proceedings. In their essence, the losses claimed in this case are not distinct losses at all. The losses after April 2015 are not in any way different losses from those before. Certainly when it comes to interest, the essential oneness of the claim can be seen by an examination of how the various heads of loss were separated out. In particular, the incremental interest figure is calculated by comparing the interest rate paid with the interest rate payable and applying that to the overdue balance. And it was apparent that the taking of 150 days as a start point was essentially an arbitrary post-120 day date. And then she talks about the breach. So the criticism is that she seemed to confuse a single breach with a single loss, and she didn't. She looked at whether the breaches were separate and whether the losses were separate. But the question is, when does a cause of action arise? So
Why isn't the interest that you've got to pay or has been incurred at the end of the first month different and discrete from the interest that you've incurred or had to pay at the end of the third year? How do you say they're the same loss?
Because I think that's just confusing damages with damage. The old distinction. The loss is the damage. The quantum of it may go up or it may go down.
What's the damage? What's the damage at the end of month one?
What's the quantum of the damage at the end of month one may be different. And in case of the
what's the damage? The damage is having suffered the loss of the time value of money for a period of a month. That's the damage that's been suffered, isn't it, at the end of the first month?
Yes, the cost of being out of funds.
And at the end of the third year, it's different damage. It's the cost of being out of funds for a different period.
And, with respect, my lord, that's confusing the question of damage with the question of damages. The damages might have increased, but the damage is the same. It's just the cost of being out of funds.
Well, the nature of the damage, it's the same kind of damage. It's being out of funds, but it's not the same damage.
My submission, it is the same damage, and that confuses the issue of damages with.
If I borrow money from my bank and I can't repay it, every day that goes by, I'm charged interest by my bank, and its interest is charged, let's say, on a daily basis per diem. That it accrues. I may only have to pay it monthly, but it accrues day to day to day to day to day. Looking at the indemnity clause, the indemnity says you have to be kept harmless from and indemnified against loss and damage. Well, what's the wording?
Loss, damage, costs and expenses.
Loss, damage, right? Losses, damages, costs and expenses. If I was to ask you to indemnify and hold me harmless, I'd sort of be coming to you every day and say, look, they've charged me another 10p. 10p, please. Tomorrow, you'll pay me another 10p because that's holding me harmless. Why isn't that happening day by day by day by day? Why isn't the thing that you have promised to do hold me harmless against?
Because
daily accretion of interest happening every day.
Yes, because the indemnity has to have a limitation, and this view that's been postulated would be so generous that it would almost take the indemnity outside statute of limitations. You know, that's.
Is it generous? The real test for it is when did you issue a claim form for it? And it seems to me you couldn't issue a claim form seeking interest in 2015. You couldn't issue a claim form then paying the interest that you are not going to incur until 2016.
Well, you could issue a claim for interest. Yes, obviously you can. I mean, you could seek a declaration or something along those lines.
Yes, but that's not the claim for the. That's not the claim that would be a statute barred under Section 5, is it? Claim that's statute barred under Section 5 is the claim for the money. And you can't make that claim until it's been incurred.
I think the point of difference. I mean, I see what you're saying.
So that's the answer point. Why is this ridiculous or unfair? Well, it isn't, because what's ridiculous or unfair is saying that somebody is statute barred from claiming a loss which they didn't suffer until 3 years ago, because it relates to a breach, an event of default which was 6 years ago, when he was actually claiming it until 3 years ago. So you're effectively far from it being unfair to allow it. It would be unfair to stop it.
I think the point of principle is whether it's a separate loss / a separate breach. I've made submissions on that. I take your lordship's point. I mean, I think what I would say is that when the party first starts incurring interest, I'm presuming that the Limitation Act encourages parties to bring their claims.
Well, it didn't encourage it, but at the end of the day, if you issued a claim form claiming interest that you hadn't yet suffered, that would be demoralising. So they'd say, well, you haven't suffered interest. of the date you issued the claim form. It's only 2015. You can't claim the interest that you might. If we haven't paid you by 2016, yes, you might pay actually declaration saying if I haven't got judgment or you haven't paid me by 2016, I will then incur interest. Would be a bit of a nonsense declaration.
I think you could obviously structure or word the indemnity in a way that said that there is a indemnity continuing or there is a right of action. But ultimately, you have to look at the actual clause. And if it is an indemnity in the way suggested, in my submission, it doesn't separate or create that right on a daily basis. Just you'll have a reference in my skeleton to a passage in Pars Banking, which talks about an argument on the facts of that case, Lord Justice Rigby, which sought to argue that there was a fresh cause of action arising every day, and that was rejected. You can maybe look at it quickly, because I'm conscious my learned friend needs time to reply, but it's a tab 2 of the authorities bundle at page 20. I've just asked you to read the first paragraph. I'm not going to labour the point. Page 20, tab 2. My Lords, may I now look at very briefly at the additional ground for upholding the judgment, the point about Clause 8. So if we can start with Clause 8, which is in the supplementary bundle, tab 4, page 38. This is the operative Amendment 3 that covers the claims, and you have the amendment to Clause A, and then what I'm looking at, you see the headline payment in euros. I'm looking at the third paragraph down from there. Any late payment from the 151st day after the bill of lading date onwards shall attract at an applicable rate of Euribor 1 month plus 4%. The point is actually quite a simple one. That's my submission. It is correct. Each of the claims, and you have the references in my skeleton, each of the claims are claims for damages for breach of contract. And the breach in each case is the same one, failure to make payment on time under the contract. And in my submission, when the parties agree a contractual interest rate, it is wrong, as was suggested as was submitted by my learned friend very eloquently yesterday, that is simply a minimum payment absent an express agreement that it is an exhaustive remedy. In my submission, the opposite applies. Obviously, it's a matter of contractual construction in each case, but it would be an odd statement to say that contractual interest provisions, unless they say expressly, by the way, you can't get your actual interest, can be just seen as a minimum payment. There's nothing here that suggests that it is a minimum payment.
If there were a claim under the indemnity if what had happened was that as a result of the late payment there'd been a termination and then there'd been a claim under the indemnity to cover losses which would not have been incurred but for the event of default, which was non-payment. Do you still say that clause 8 would prevent any claim under the indemnity because it's a liquidated damages clause?
If I was wrong about what the meaning of indemnity is, then it could do. But understand that it was conceded yesterday.
Just take different facts. Assume that there is late payment of the price, and it's relied on for early termination, and the claim is then brought under clause 26, saying that these incremental damages are costs that I would not have incurred but for the event of default, and they fall within clause 26. If those were the circumstances, do you say that clause 8 is a liquidated damages clause in relation to an indemnity claim, or do you say it's only a liquidated damages clause if the claim is framed for breach of clause 8 itself?
So if the judge is right on her construction, that it is a general indemnity, but it is restricted to those operating conditions, then it could override clause 8. My position, or my client's position, is stronger than the judge's finding, which is that...
Sorry, I just want to have your submission. So your submission is it's a liquidated damages clause if the claim is for breach of clause 8, but not if the claim is for an indemnity under clause 26. Right. I'm recording what you're saying.
No, I'm not. No, I don't accept that. I think that the court will have to then look at a tension between the alleged indemnity and clause A. And that tension is obviously a reason why I say that the indemnity doesn't operate at all. Alternatively, the judge is right that it's confined to certain...
Well, I was rather expecting you to say that it applies to the indemnity as well, because I thought one of the arguments that you adopted was you have to construe clause 26 in a way which doesn't cut across any of the other clauses.
Yes, but there's two ways of doing that. One is to say that subparagraph 5 is a surplusage, which was my position. The other way is to say what the judge said, which I would then accept, which is that it is not surplusage. It does create an indemnity, but only in those operating conditions. That's why I keep qualifying what I'm saying. But if the judge is right, that it is an indemnity, but in a subset of circumstances, then...
Can I try and put a practical example of the question my Lord has put to you?
Yes.
Which may or may not help. Suppose that there is a non-payment amounting to an event of default, and the seller goes off to its lawyers and said, please can you advise me, is this an event of default that would entitle me to serve a termination notice? And the lawyers say, yes it is. Here's our bill for giving you that advice.
Mm-hmm.
And the seller then serves a termination notice on the back of that advice and says, please pay up under clause 26.4, here's our lawyer's bill that we had to get advice about, which wouldn't have occurred had the event of default not occurred. Can they or can they not recover that under clause 26?
I would say no. Alternatively, you could say that clause 8 is only dealing with the time aspect of being kept out of the money.
Are you saying that the legal bill that they had to pay because they had to get advice about whether it was an event of default, wouldn't occur but for the event of default, is ousted by clause 8? The indemnity is rendered nugatory because of the provisions of clause 8. Is that what I understand the argument?
Possibly not. Well, on a wider view of clause 8, on my argument, yes, because I would say any consequence of late payment is covered by the interest. However, I accept that's not a particularly attractive argument. So I would say that might not be covered by clause A because it is not a time consequence. But what we are looking at here is they're literally taking the actual interest and saying, I want the actual cost of borrowing, nothing to do with going to a lawyer, nothing to do with terminating. I want the actual cost of borrowing.
I thought my lord was, maybe I misunderstood the question that was being put. But in essence, I think what I was putting to you, whether clause 8 on your argument would prevent a claim under clause 26 of the type that I'm just.
No, not if the judge is right in clause 26. It would.
I thought your argument is, as I understand it, is that clause 8 effectively disapplies the whole of clause 26 in relation to non-payment. You're saying that clause 26, clause 8 is the exclusive remedy, and there's no other remedy.
Well, my main point is clause 26 doesn't apply on these facts because there has not been that subset of circumstances, notice of an event of default and so on. So I think the question was being put just a matter of construction on it. I think that was what you
I'm
were.
just trying to understand,
Yeah.
I'm just trying to understand how you say these two clauses are supposed to work together. So I thought was the question.
I misheard you, because I thought you said clause 8 is the sole and exclusive remedy for non-payment.
Yes.
So if that's the case, then clause 26, the whole of it, is inapplicable to an event, what would otherwise be an event of default of non-payment.
Well, I wouldn't necessarily say it's inapplicable. I think it was agreed yesterday that any clause in this contract limiting recovery supersedes clause 26. I thought that was accepted yesterday.
It's in relation to clause 26, what we have identified as 26.4. Your argument is that the whole of 26 is disapplied, as I understand it. You can't even terminate for non-payment.
No, I'm not suggesting you can't terminate for non-payment. Obviously, that it's still a default. What I'm saying is that the parties have agreed.
It's the sole and exclusive remedy.
No, it's the agreed damages.
There are 4 remedies set out in clause 26.
I'm sorry.
So either.
No, I'm not suggesting that at all. Sorry, we're cross purposes. I'm not suggesting that it is the only remedy. I'm saying that it is the agreed damages for this breach of contract. I'm not saying, sorry, that might be why I've been, I'm not suggesting at all that clause 8 displaces remedies. What I'm saying is that clause 8 fixes the damages for this breach of contract. That doesn't mean you can't suspend for it, you can't terminate for it, and so on and so forth. You can do all that. But it liquidates or it fixes the compensation for being kept out of this money on a daily basis.
And it only kicks in a certain period of time after the event of default, after the failure to make payment, doesn't it?
Yes.
So in my example of going off to your lawyer shortly after the non-payment and just saying that does amount to an event of default that entitles me to serve a notice of termination, you in fact wouldn't get any, you in fact wouldn't be able to claim back your legal fees that you would have, the seller would not have incurred but for the event of default.
Or I think you could, if there were legitimate fees of exercising your clause 26 rights, then they would be claimed as clause 26 rights.
But how can they be if you're saying clause 8 is the sole remedy for that breach, namely the failure to make a payment?
No, I think that this is what I'm trying to clarify. I am not saying that clause 8 is a sole remedy for the breach. I'm saying that clause 8 is a sole measure of damages for being kept out of the money. So you could still terminate, you could still suspend, etc. And if you have an attendant cost to terminating or notifying and so on, then you get that as attendant cost of exercising that right. The point, one of the points made yesterday was that if clause 8 intended to restrict or remove the right to claim actual interest, clear words would be needed to that effect. But the authorities, in my submission, say the opposite. If we go to the Chatham Developments case, which is in the authorities bundle at tab 13, at page 184, paragraph 31 from Mrs Justice Ramsey.
I think in fairness to Mr Young, you're going to have to wrap up in the next 5 minutes.
Yes. So I'll ask you to read paragraph 31. I will wrap up in 5 minutes, and I apologise to Mr Young. As a result, paragraph 31, as a result, when there is a valid and enforceable liquidated and ascertained damages clause within an agreement, those damages are the sole remedy for the particular breach to which they relate, commonly delaying completion. Unliquidated damages are not recoverable because the parties' agreement of liquidated damages replaces a remedy which would otherwise be available for breach. As can be seen from Temlock, the question of whether unliquidated damages could be recovered was a matter of the interpretation of the agreement, from which it was possible to find a clear intention to exclude that remedy. In the case of a written agreement, that clear intention can be usually derived by construing the terms of the written agreement as a whole. For example, it was not necessary in Temlock for there to be an express exclusion clause to preclude the remedy of unliquidated damages. And I say that although obviously it is always a matter of construction in each case, this is really suggesting the opposite, that if you have a set damages rate, then you don't need to say, oh, by the way, you can't claim further damages under the common law. That is a natural construction of that contract. And I think it would be a surprising argument. I mean, interest rates are rife across many kinds of contracts that involve payment. And you don't often find in them the sentence added, oh, by the way, you can't claim your actual costs of borrowing. But it is taken as a given that they will dictate what can be recovered for late payment. We may get into tricky areas as to whether they cover the kind of attendant costs that your lordships are mentioning, and that will have to be looked at on a case-by-case basis, depending on the contract and the loss. But this is quite a simple case. They're saying, okay, you've paid us the 27 million in actual interest, in contractual interest. We've actually incurred more, so we want the rest.
I think you've got two alternative cases. One is it quantifies all damages for breach of clause 8. The fallback is it quantifies damages insofar as there are claims for the time value of money.
Yeah, I think the second one might be the more accurate position and the easier submission for me to make. My Lord, with apologies to Mr. Young, I'll sit down.
Thank you. Yes, Mr. Cockerill.
Please, Your Lordship. I will take things in reverse order, if I may. Principally because most of the points that I want to make on the settlement agreement issue are points which, it seems to me at least, all of your lordships are alive to, and therefore I'd be saying something that was utterly irrelevant. Whether they're good points or bad points doesn't matter. So if I can just take reverse order, and whatever time is left, I will go to the second agreement. If clause 8 had been expressly a liquidated damages clause, then it might have been different. But it isn't. It's not like the JCT form, it's not like demurrage, which we all know about. It's just, what it is an automatic right to payment, not even necessarily in the event of an actual breach of contract, because it starts the interest running from an earlier point. So it's not even referable necessarily for breach. And that's the end of the liquidated damages point. What clause 8 does is provide an automatic remedy, essentially by way of enhancement of the price, which is not dependent upon proof of loss. Clause 26, however, is dependent upon proof of loss. And if I may respectfully say so, that is the critical point in the construction of that clause. Now, I'm going back, sadly, nearly 50 years when I did the bar finals, and I was taught when you plead a cause of action, you've got to plead all facts which are necessary to justify the claim that you are making. Clause 26 makes it a necessary fact to be pleaded that there is loss, damage, costs, expenses, legal fees. Those things are critical to the cause of action for the indemnity under clause 26. They are not relevant in a simple claim for breach of contract, because you don't need to allege loss in a claim for breach of contract. That's why we have nominal damages. So the accrual of the cause of action depends upon the pleading of the loss which is being claimed, and that then answers my learned friend's point.
I'm not sure. Sorry, I'm not sure I follow that. I mean, if you promise to indemnify me against loss, and I say I'm suffering loss, and I will continue to suffer loss, please indemnify me, and you say bugger off, I'm not going to. I have a cause of action which I would be entitled to pursue I'd be entitled to issue my claim seeking an order and declaration that you indemnify me for the future.
Two things. One is that was the point, as I recollect, arose in the ex parte St Thomas's Hospital case in about 1911. I'm going to hazard a guess, 1911 2 King's Bench. I think it was something like that, where that very point was developed, and the Court of Appeal said, I think Lord Justice Fletcher Moulton said, no, you can actually have a declaration of a right to indemnity, but it doesn't necessarily mean that the cause of action for loss damages.
No, but my cause of action would be breach of contract. You would have repudiated the contract of indemnity.
And one would say then that the denial of the right, the denial of the remedy, as you put it, the bugger off, would be a repudiation and would be capable of being accepted. And then you would have the cause of action accruing as at the date of acceptance. But in this case, all we need to do is to establish that the cause of action under clause 26 in respect of loss, damage, whatever, doesn't accrue until they have been incurred. It's a past participle, incurred. And it's incurred but for the event of default. There's no assimilation of any exercise of rights at termination. So, I mean, that's my point, my lord, whether it's a good point or a bad point.
It doesn't matter if you might have a cause of action which is statute barred, if you have other causes of action which aren't statute barred.
My lord, exactly, yes. I mean, there are two creatures, both intended to provide some form of remedy, but in a different way and in different circumstances. But the cause of action in respect of the loss accrues only when the loss is incurred.
Under the indemnity, and that's
the indemnity, yes. And the holding harmless. As soon as you suffer harm in respect of that particular loss, then
yes, it may not help very much.
I mean,
look at other causes of action. I mean, we know in tort you have to have some damage as an ingredient of the cause of action, and there's a lot of very complicated law about time starting to run, even though you continue to suffer damage, and it's got to be the same kind of damage. And in building cases, it may have to be patent, all those difficulties. But that just doesn't help.
Also applies to, it also is the case that you might have a cause of action for a declaration. Well, yes, but so what?
Yes, and that's why I say I have it in mind the St Thomas's Hospital, and I'm.
So you sort of, I think your point to me is I was postulating the wrong type of relief that would be, so it's not relevant. You were postulating, my lord, I think a situation where I think what I was picking up, and maybe I was is that I think you were asserting that a cause of action in contract only arose when you suffered loss.
Which is not right. The cause of action for a breach of contract it arises when the breach occurs, whether or not there's loss, and that's why you don't have to plead loss.
But you say in this context.
This one you do. It's either a good point or a bad point. My lord, as for limitation, well, that probably deals with most of limitation. I would say two things. One is, on the learned judge's own reasoning, this was a claim for a liquidated pecuniary sum because the parties had agreed it. So the only question then is whether there should be whether there's an acknowledgement. And my only point is that if describing a claims as being undisputed is not an acknowledgement, then then that's the case. But it's just on the particular facts of this case. My learned friend referred to the judgment of Mr. Justice Jackson, as he then was, in the Cymru case. That was a case in tort, where there was a damages claim in tort. And what Mr. Justice Jackson held was that a damages claim in tort doesn't come within liquidated pecuniary loss. That's all he decided. He gives a very, very good account of the history of the Limitation Act, but it's only in respect of tort. What he said, my learned friend did say at one stage, he said, this is section 29.5, he said, claims for damages for breach of contract will never qualify. That is, if I may respectfully say so to him, wrong. Damages for breach of contract may or may not, depending upon the nature of the damage suffered. But it may or may not be liquidated pecuniary loss, so be it. Then it doesn't. But breach of contract don't necessarily fall outside 29.5. Let us take, for example, the marriage, which is technically it's a claim for damages. It's a breach of contract in failing to load or discharge within the allowed load time. But it's a breach of contract, but it falls within the Act. If in any particular set of circumstances there is or is not a liquidated pecuniary claim, then so be it. But it's that which defines the operation of section 29.5, not the characterisation of the cause of action. My lords, that brings me to the settlement point.
6 minutes.
I got 6 minutes. My lord, my learned friend showed you Barbudev. It's quite a complicated case, which does require some consideration of the facts. But at the end of the judgment, there is the Lord Justice Aikins set out the term of the side letter. I think in order to understand the full impact of the case, it was a claim by somebody who sold an interest in a Bulgarian cable TV channel on the understanding that he was going to be able to acquire a percentage interest in the acquiring company. The sale of the shares of the Bulgarian company was governed by an SPA, which had a provision in it saying that the question of the seller's acquisition of a shareholding in the acquiring company was to be the subject of a shareholders' agreement, but either party could waive the right to the conclusion of the shareholders' agreement. The Rotters, who were the buyers and shareholders of the acquiring company, issued a side letter upon which Mr. Barbudev, as the seller and thwarted investor, then sued, and he didn't recover, not because, as Mr. Justice Blair held, the side letter was not intended to create legal relations, and that was the point which has been shown. But if you look at the end, the side letter as set out is about as clear a case as you can imagine of an agreement to agree. If you see the heading investment agreement, in consideration for you agreeing to enter into the proposed transaction and to sign the transaction documents, the purchaser hereby agrees that as soon as reasonably practicable after signing of the agreement by all parties, we shall offer you the opportunity to invest in the purchaser on the terms to be agreed between us, which shall be set out in the investment agreement. and it was the investment agreement that was in the event never concluded. And then the management contract at the bottom, we also agree that you shall be offered the opportunity to continue as manager. And what the Court of Appeal, Lord Justice Aikins held, was, well, that is just not an agreement upon which Mr. Barbouillet could sue for breach. If my learned friend relies upon it, I think one does have to put it into context. Now, looking at the point about the settlement agreement, my learned friend used the term tail wagging the dog. Well, yeah, I agree. This is a case of the tail wagging the dog, but the tail is the further negotiations. The dog is the undisputed. I couldn't think of a more clear example of a canine in this case. If the parties had wanted to say, our Sonara's agreement to this is subject to the agreement of the government of Cameroon, it would have been the simplest and easiest thing to say. As my Lord Justice Phillips has pointed out, these parties knew that they could write in a subject if they wished to. So in my respectful submission, when they don't do that, you should look at to see if there's something very clear which indicates that undisputed means disputed. And I say disputed, because it must mean if either liability or quantum is disputed, then the whole thing is disputed. It's not, and you can't parse it up.
Well, it had been so designated by Sonara in the earlier draft.
Indeed, indeed. And I'm very, very anxious to avoid falling into the trap which my Lord Justice Snowden identified me falling into, which is sort of mixing up construction and background.
No, insofar as those are relied upon by Société,
Yes.
and you're entitled to say, well, there we are.
Yes. Well, what I was going to say was that I think my Lord Justice Snowden thought that I was engaged in a paring down exercise of construction, which is highly probable. But I went through the wording of the agreement, joint report, intentionally to look at the wording. Then I looked at I think, indisputably, if I can use that term, admissible context. And we know since the Investors' Compensation Scheme and Arnold of Britain, Gordon Capita, we've got to look at language and context. The context, I think both of us are agreed what the context was. It was the fire and the catastrophic consequences on the finances of Sonara and the banks breathing down our neck and threatening us with hell and damnation. You look at it in that context, and you can see that once this agreement had been concluded, it was then going to go off, and Sonara were going to put it to the government to get money. The government might or might not provide it. The learned judge has said it was agreed that it should be indisputably due. Well, what makes it indisputable is if Sonara have agreed it. They don't. They're not going to have to go into an argument about of English law about the construction of Clause 8 and Clause 26. That is frankly ludicrous, particularly within the 2 weeks that are allowed. So it was anticipated, I would respectfully suggest that they were going to go off and see if they could get money from the government with which to satisfy it. They might need payment terms, they might need a schedule of payment. It's just possible, and this is where I think there may have been a misunderstanding on my learned friend's part. It is just possible that the government would say, well, we can't give you that much money. So they would come back and they'd have to unstitch the undisputed and agree a new disputed sum. And that would be the further negotiations. And what we were saying was, we acknowledge that, and it's worth remembering, it says Sonara to propose flexible payment terms, schedule, and further negotiations. It would be necessary for them to propose it. It wasn't as though the contract was incomplete as it stood. It was entirely complete, but it was contemplated by all that it might need to be reconsidered depending upon the availability of funds. I think
That's out of time.
I think that also deals with everything that I wanted to say, and all of the other points I wanted to make, I think, have emerged from your lordships, whether good, bad, or not. Unless I can assist you further.
Okay, thank you.
I'm sorry to have gone on another 5 minutes. I'm so sorry about that.
That's all right. That looks a little bit fast.
Is it?
All right.
Actually,
Well,
it is fast.
we will reserve our judgment. You will have it in draft in the usual way. As you know, typographical and administrative errors, not an opportunity to re-argue points. You'll all be aware.
Not further negotiations.
You'll all be aware of the importance of the embargo, and
Yes.
we'll make sure that those who have access to it are aware of the importance of the embargo. Could you please try and agree an order to reflect the outcome? If you can't agree it, put your rival submissions in writing and we'll decide on paper.
Could I just ask if your lordships want any documents in Word? If you could just let us know, we'll provide it. If you don't,
I think I indicated I would like the judgment and the skeleton arguments and,
yes.
and
If there's anything
and,
else,
and the contract.
yes. Okay. Yeah. We'll provide that. I'm sorry.
All right.
All rise, please.
Tim, sorry it took longer than I said.
Oh, these things happen. Don't worry, I need to be truncated.
Now, please remind the courtroom that the live stream is still running despite the screen.
Oh, right. Yes. In which case, I don't want to go as admitting that I was wrong. Thank you.
Oh, well,
Thank you very much, everybody.
figure out a solution. Yeah, sure. There we go.
It's hard work, isn't it?
It's fun though. I mean, it's
It's fun.
you boys did excellent. Well done, both of you. Thank you for giving them the opportunity.
Rather like let's go John T. Just reminding court and say whatever is.
Subject to
Yeah, that was it.
so there's an original case.
Bye bye everybody. Cheerio.
Oh yeah.
So this is valid.
Yeah.
Which year are you in?
Freshman.
I started, so I've already done a degree. So I did my undergraduate degree. And now I'm
Also,
doing
yeah.
job. Version course.
Okay. What do you call that course? It's not LLM.
Thank you very much.
Oh, well then, if you've got a ticket, go use the Heathrow Express. You're going to join us for tea, or are you heading off? What time?
Thank you very much.
Thank you.
Anyway, bon voyage.
Merci.
Bon vol.
À très bientôt. Salut.
J'espère à la prochaine.
No, I hope there won't be a prochaine. There won't be a prochaine.
No, actually, you're right. I hope we never meet again. I hope we never meet again.
Not quite that bad.
Sorry, excuse me.
Thank you so much.
I knew it would fall.
Cheerio. See you soon.
Sorry, just behind. Have a nice evening.
You too.